A man lays sticks and turf over a pit. He knows death is likely if someone walks over it. Someone does. They die. Another man fires a cannon into a crowd. No specific target. Someone dies. A third man loses his temper in a fight, pulls out a knife, uses it. Someone dies. 3 deaths. 3 different answers from the law. Today, we find out why. This is Narrator, Analyst, Practitioner, Scholar Channel. I'm the narrator. I hold the thread, ask the questions, and keep the conversation grounded. With me are 3 voices who will take this apart from every angle. Let me bring them in.
I'm the scholar. My work sits at the intersection of legal history and philosophy, asking not just what the law says, but why it says it, what it's trying to protect, and what it reveals about the society that built it. Today we're going deep into 2 sections that have anchored Indian criminal law for over many years, and I find them endlessly worth thinking about.
I'm the practitioner. I've spent years in courtrooms where these exact distinctions, these precise words in these precise sections, determined what happened to real human beings. The scholar works with ideas. I work with consequences. And on the best days, those 2 things align.
And I'm the analyst. I look at law as a system, its internal logic, its architecture, and whether its design holds up when tested against the full range of human behavior. Today we're going through Section 100 and Section 101 of Substantive Law, India BNS, word by word, illustration by illustration, exception by exception. Nothing skipped, nothing glossed over.
4 perspectives, 1 conversation, and a question the law has been refining its answer to for more than a century and a half. What exactly separates culpable homicide from murder? Let's find out. Analyst, let's start at the foundation. Section 100 Substantive Law in India, BNS. What does it actually say?
Section 100 Substantive Law in India, BNS, opens with this. Whoever causes death by doing an act with the intention of causing death, or with the intention of causing such bodily injury as is likely to cause death, or with the knowledge that he is likely by such act to cause death, commits the offense of culpable homicide. 3 mental states, 3 separate routes into the same offense. First, direct intention to kill. Second, intention to cause injury serious enough to likely cause death. Third, knowledge that the act is likely to cause death, even without any intention to harm. You don't have to want to kill someone. You just have to know that what you're doing is likely to kill them.
And the word culpable is doing a lot of work here. It doesn't just mean illegal. It means blameworthy, morally answerable. The law is not simply recording an outcome. It is making a judgment. It is saying, this death is not an accident. This death belongs to you. That distinction between accident and culpability is as old as law itself, and it rests entirely on what was happening in your mind.
And Section 100 Substantive Law in India, BNS, gives us illustrations to make that concrete. Let's go through them.
3 illustrations. First, person A lays sticks and turf over a pit with the intention of causing death or with the knowledge that death is likely to be caused. Person Z, believing the ground to be firm, treads on it, falls in, and is killed. A has committed culpable homicide. The act was deliberate, the trap was set, the knowledge was there. Even though person A was not physically present when person Z died, culpable homicide stands.
That illustration establishes something fundamental. You don't need to be the direct physical cause of death. You can set the conditions, create the lethal situation, walk away, and still be held responsible. The chain of causation doesn't break just because the accused wasn't standing there.
Second illustration. Person A knows person Z is behind a bush. Person B does not know. Person A, intending to cause or knowing it to be likely to cause person Z's death, induces person B to fire at the bush. Person B fires and kills person Z. Person B may be guilty of no offense, but person A has committed culpable homicide. The person who pulled the trigger is innocent. The person who orchestrated it, guilty.
That illustration captures something about criminal responsibility that moral philosophy still debates. The person who acts is not always the person who is responsible. Using another person as an instrument, while concealing your own knowledge, does not insulate you. If anything, it deepens your culpability.
Third illustration. Person A shoots at a foul, superorder of birds intending to kill and steal it. He kills person B, who was hidden behind a bush. Person A did not know about fact person B was there. Here, person A is not guilty of culpable homicide because he did not intend to kill B and he did not know his act was likely to cause person B's death. He was doing an unlawful act, poaching, illegal hunt. But that unlawful act alone is not enough to make a death culpable homicide.
That third illustration is the one defense lawyers love. It shows the law has limits. Not every death that follows an unlawful act is culpable homicide. The mental element must be present. And if it genuinely isn't, the law recognizes that. In practice, the hardest cases are always the ones where intention is genuinely ambiguous.
Section 100 Substantive Law. In India, BNS also contains 3 explanations. Dealing with boundary situations, the main definition alone doesn't resolve. Scholar, walk us through them.
Explanation 1. If a person causes bodily injury to another who is laboring under a disorder, disease, or bodily infirmity, and thereby accelerates the death of that other person, they shall be deemed to have caused death. The victim's pre-existing condition does not let you escape. You take your victim as you find them. If you strike someone who has a heart condition, and that strike kills them, you caused their death. Their fragility is not your defense.
That first explanation is one of the most practically important things in this entire section. I have seen accused persons argue. The victim was already sick. A healthy person would have survived. Explanation 1 closes that argument entirely. The law does not require the victim to have been in perfect health. You struck them. They died. You are responsible.
Explanation 2. Where death is caused by bodily injury, the person who causes that injury shall be deemed to have caused death, although by resorting to proper remedies and skillful treatment, the death might have been prevented. The accused cannot point to inadequate medical care as a shield. If your blow caused the fatal injury, the fact that a better surgeon might have saved the victim does not break your chain of responsibility.
That second explanation matters for a systemic reason. Without it, accused persons would routinely argue the real cause of death was inadequate treatment, not the original injury. The explanation prevents that gap from being exploited. The causal link from blow to death remains intact.
And explanation 3 is the most philosophically delicate. The causing of the death of a child in the mother's womb is not homicide, but it may amount to culpable homicide, to cause the death of a living child if any part of that child has been brought forth, though the child may not have breathed or been completely born. The threshold is partial birth, not breathing, not full delivery. The moment any part of the child has emerged, the law's protection begins.
So Section 100 of the Substantive Law in India, BNS, is the foundation, the full definition of culpable homicide, with its illustrations and its 3 explanations. Now we move to Section 101, and this is where the law draws its most consequential line. Analyst, Section 101. 4 conditions. Take us through them precisely.
Section 101 opens, except in the cases herein and after accepted, culpable homicide is murder in 4 situations. Condition A, if the act by which death is caused is done with the intention of causing death. Straightforward. You meant to kill. Condition B, if the act is done with the intention of causing such bodily injury as the offender knows to be likely to cause the death of the particular person to whom the harm is caused. The key word, particular person. You knew this specific individual was likely to die. Condition C. If the act is done with the intention of causing bodily injury to any person, and that bodily injury intended is sufficient in the ordinary course of nature to cause death, the harm itself is objectively fatal, not because of the victim's particular vulnerability, but by the standard of any ordinary human being. And condition D. If the person knows that the act is so imminently dangerous that it must in all probability cause death, or such bodily injury as is likely to cause death, and commits the act without any excuse for incurring that risk.
The distinction between condition B and condition C is one of the most subtle and most important in the entire framework. Condition B is about knowledge of this victim's specific vulnerability. Condition C is about an act that is objectively lethal, regardless of who it targets. The law recognizes both routes to murder and handles them separately because the moral situation is different, even when the outcome is the same.
And the Section 101 substantive law in India, illustrations, bring that distinction to life brilliantly. Condition A. Illustration A. Person A shoots person Z, intending to kill him. Person Z dies. That is murder, simple, direct. Condition B can be explained by an illustration in two ways. Illustration B. Person A knows person Z has a disease. Person A knows that even a single blow could kill him. Person A strikes person Z anyways. Person Z dies. This is clearly murder, knowing that person A had knowledge and clear intention of killing because person A knew of person Z's specific vulnerability. But flip it. If person A had no idea about person Z's condition, and the blow was not the kind that would kill a healthy person, person A is not guilty of murder. Same act. Completely different outcome in law. Because the one thing that changed was knowledge.
Illustration C reinforces condition C precisely. Person A intentionally gives person Z a sword cut or club wound sufficient to cause the death of a man in the ordinary course of nature. Person Z dies. Person A is guilty of murder, though AA may not have intended to cause person Z's death. The act itself was objectively fatal. The deliberate choice to inflict that level of harm is enough, even without a specific intention to kill.
And illustration D is the one I find most striking. Person A, without any excuse, fires a loaded cannon into a crowd of persons and kills one of them. Person A is guilty of murder, although he may not have had a premeditated design to kill any particular individual. No target, no plan, no specific victim in mind. But condition D is fully met. Imminently dangerous, near certain probability of death, no excuse for that risk.
Condition D is philosophically the most interesting because it says, at some point, the degree of recklessness becomes morally equivalent to intention. If you know with near certainty that your act will kill, and you do it anyway with no justification, the law will not let you hide behind the absence of a stated goal. The conscious disregard of near certain death is itself treated as a form of intention. That is a profound moral judgment embedded in statutory language.
Now, here is where the law does something remarkable. It acknowledges that even intentional killing, in certain human situations, should not carry the full weight of murder. 5 exceptions. Analysts explain every one of them.
Exception 1. Grave and sudden provocation. Culpable homicide is not murder if the offender, whilst deprived of the power of self-control by grave and sudden provocation, causes the death of the person who gave the provocation, or causes the death of any other person by mistake or accident. But 3 things disqualify the exception. The provocation must not have been sought or voluntarily provoked by the offender as an excuse for killing. It must not have come from anything done in obedience to the law or by a public servant acting lawfully. and it must not have come from the lawful exercise of the right of private defense. And the law itself states whether the provocation was grave and sudden enough is a question of fact. Every case is judged on its own circumstances.
6 illustrations under Exception 1, and each one is worth understanding. Illustration A. Person A, under passion from a provocation by person Z, intentionally kills persons Y and Z's child. This is murder inasmuch the provocation was not given by the child, and the death of the child was not caused by accident or misfortune in doing an act caused by the provocation. You cannot kill an innocent third party and claim provocation from someone else. Illustration B. Person Y gives grave and sudden provocation to person A. Person A fires at person Y but accidentally kills person Z, who is nearby and out of sight. Not murder, but culpable homicide. The provocation was genuine. The death of person Z was accidental. Illustration C. Person A is lawfully arrested by person Z. A bailiff, an official in a court of law who keeps order, looks after prisoners. Person A is excited to sudden and violent passion by arrest and kills person Z. This is murder inasmuch as the provocation was given by a thing done by public servant, in the exercise of his powers. Illustration D. Person A is a witness before a magistrate Z. The magistrate Z accuses person A of perjury, the offence of wilfully telling an untruth or making a misrepresentation under oath. Person A is moved to sudden passion and kills the magistrate Z. This is murder. Words from someone doing their lawful duty do not qualify. Illustration E. Person A tries to pull person Z's nose. Person Z, exercising private defence, physically restrains person A. Person A is moved to sudden and violent passion in consequences and kills Z. This is murder, inasmuch as the provocation was given by a thing done in the exercise of the right of private defence. And illustration F8, the most layered one. Person Z strikes person B. Person B is by this provocation excited to violent rage. Person A, a bystander, intending to take advantage of B's rage and to cause him to kill person Z, puts a knife into person B's hand for that purpose. Person B kills person Z with the knife. Person B may have committed only culpable homicide, but A is guilty of murder. They engineered the provocation, deliberately manufactured it to cause a killing.
Illustration F is the one that still surprises lawyers when they first read it carefully. The person who physically committed the act may get the benefit of provocation, but the person who manufactured that situation, who deliberately put a weapon in enraged hands, gets no such benefit. The law sees through the engineering, and it answers it with murder.
Exception 2. The right of private defense. Culpable homicide is not murder if the offender, in the exercise in good faith of the right of private defense, exceeds the power given to them by law and causes death without premeditation and without any intention of doing more harm than is necessary for the purpose of defense. The illustration: person Z attempts to horsewhip, a long whip used for driving and controlling horses. Person A, not in a manner likely to cause grievous hurt. Person A draws out a pistol. Person Z persists in the assault. Person A, believing in good faith that he can by no other means prevent being horsewhipped, shoots Z dead. Person A has not committed murder, but only culpable homicide. The response was disproportionate, but it was not premeditated, and Person A genuinely believed it was his only option.
Exception 2 is a recognition that self-defense situations are chaotic, that people in genuine fear do not always calibrate their response perfectly. The law does not demand perfect proportionality under pressure. It demands good faith and the absence of premeditation. Those two things together, and the law steps back from murder.
Exception 3. A public servant or someone aiding a public servant, acting for the advancement of public justice, who exceeds the powers given to them by law, and causes death by an act they in good faith believe to be lawful and necessary for the discharge of their duty. and without ill will towards the person whose death is caused. Not murder. Good faith belief in lawfulness, combined with absence of malice, takes it out of the murder category. Exception 4. Sudden fight. Culpable homicide is not murder if it is committed without premeditation in a sudden fight, in the heat of passion, upon a sudden quarrel, and without the offender having taken undue advantage or acted in a cruel or unusual manner. And a critical explanation: it is immaterial which party offered the provocation or committed the first assault. Who started the fight does not determine who gets the benefit. What matters is premeditation and whether undue advantage was taken. Exception 5. Consent. Culpable homicide is not murder when the person whose death is caused, being above the age of 18 years, suffers death or takes the risk of death with their own consent. And the illustration is sobering. Person A, by instigation, voluntarily causes Person Z, a child, to commit suicide. On account of Z's youth, Z was incapable of giving consent to his own death. Person A has therefore abetted murder. Consent requires capacity. A child cannot consent to the risk of their own death, and someone who manipulates a child into death has not found a shield in this exception. They have found a charge.
The exceptions don't exist in a vacuum. Courts have spent decades defining their edges. Practitioner, what has judicial interpretation added?
3 critical areas where case law has done essential work. First, the meaning of the word sudden in Exception 4. The courts have been very clear on this. The word sudden applies to both the fight and the quarrel. The issue before the court, in the case citation, Dharmaraj versus the State of Maharashtra, 2019. SC's C Online Bombay, 209, was whether the accused could get the benefit of Exception 4, sudden fight, which means if there was any time between the quarrel and the killing for the passion to cool down, it cannot be called a sudden fight. The Bombay High Court put it plainly in Dharmaraj versus State of Maharashtra. The accused climbed 5 floors before committing the act. The court said, that climb was enough time. Enough time for the heat to fade. Enough time for a decision to form. And once a decision forms, you are no longer acting in sudden passion. You are acting with intent.
Second, who bears the burden when claiming provocation? In the case of Suklal Sarkar versus Union of India, 2012, 5 SCC 703, the Apex Court said, the person claiming the benefit of provocation has to show 3 things: that the provocation was grave and sudden, that they were deprived of the power of self-control, and that they caused death while still in that state of mind. All 3 together. The burden does not sit on the prosecution to disprove provocation. It sits on the defense to establish it.
Third, and this is the deepest piece of reasoning in this area, citation. Budi Singh versus State of Himachal Pradesh, 2012, 12 SCC 663. The Apex Court in India drew a critical distinction between sudden and grave provocation resulting in sudden and temporary loss of self-control, and provocation which inspires an actual intention to kill.
And the Apex Court in India. Citation. Arun Raj versus Union of India. Year 2010. 6. SC C 457. Gave us the clearest statement of why the provocation exception exists at all. The exception is there to take into consideration situations where a person with normal behavior reacts to the given incidence of provocation. The protection is extended to the normal person acting normally in the given situation. And courts must examine it from the point of view of a person of reasonable prudence, asking whether there was such grave and sudden provocation that it was reasonably possible to conclude the killing was culpable homicide, not murder, not any person, a reasonable person. That standard is everything.
All of this classification, all of this precision, leads somewhere. It leads to what happens to a person's life. What is your opinion on this practitioner?
Section 103, subsection 1, Substantive law in India BNS says following: Whoever commits murder shall be punished with death or imprisonment for life, and shall also be liable to fine. And Section 105, Substantive law in BNS says, Whoever commits culpable homicide not amounting to murder shall be punished with imprisonment for life, or imprisonment of either description, for a term which shall not be less than 5 years, but which may extend to 10 years, and shall also be liable to fine, if the act by which the death is caused is done with the intention of causing death, or of causing such bodily injury as is likely to cause death, or with imprisonment of either description for a term which may extend to 10 years, and with fine, if the act is done with the knowledge that it is likely to cause death, but without any intention to cause death, or to cause such bodily injury as is likely to cause death. That gap, between a 10-year ceiling and the possibility of execution, is one of the largest sentencing gaps in the entire criminal code. And it rests entirely on everything we have discussed today. Whether person A knew of person Z's disease, whether in case of Dharma rage versus the state of Maharashtra, as discussed, the accused could get the benefit of exception 4, sudden fight, and cooling period time, whether the provocation was genuine or engineered. These things determine decades, sometimes a life.
Do you have anything to say, scholar?
Yes, I would like to say, on the death penalty, Indian courts developed the rarest of rare doctrine to govern its use. Capital punishment is given in the cases that shock the collective conscience of society. The law grants the judge the power, but precedent has built guardrails around when that power should actually be exercised. Those guardrails came not from Parliament, but from judgment after judgment, court by court, case by case. That is law evolving exactly as it should.
So, analyst, what is your opinion from the system's perspective?
From a systems perspective, the survival of this framework from so many years is itself an indication. The architecture was preserved, the illustration survived, the exceptions survived. What changed was language and numbering, not structure. A legal framework that endures across colonial rule, independence, and codification reform is telling you something. The design was fundamentally right. Not perfect, but built to last.
What strikes me every time I return to sections 100 and 101 is the law's refusal to treat human beings as interchangeable units of harm. The person who set a trap and walked away, the person who struck someone whose fragility they knew, the person who planned a killing for days. The law looks at each of them differently, not because the outcome differs, but because the person does. That insistence is one of the most important things law has ever done.
I have stood in courtrooms arguing every part of what we discussed today. The pit trap, the pre-existing condition, whether the provocation was genuine or engineered. What I can tell you from that room is that the precision of this framework matters more than any textbook can communicate. A word, a single exception. Whether a court believes the passion was still burning, these things determine decades of a person's life. Precision is inbuilt in every process.
The framework we walked through today is elegant. It is elegant because it is honest about complexity. It does not pretend all killings are the same. It does not pretend all intentions are equally blameworthy. It builds gradations and commits to them for many years of use. That is what good legal architecture looks like. Not the absence of gray areas, but a principled, honest way of navigating them.
A man who laid a trap. A man who fired a cannon into a crowd. A man who lost his temper in a fight. The law does not see 3 identical events. It sees 3 different minds, 3 different states of intention and knowledge, 3 different moral situations, deserving of 3 different answers. That capacity to look past the outcome and into the person is what separates justice from mere punishment. The law asked one question that mattered. Not what happened, but who were you when it did? Thank you for listening this episode.